Making sense of the day's news agenda. Power Perspective with TT on Power 98.7.
Right, let's turn our attention to this matter then. So the Minister of Home Affairs has failed in his bid to overturn an interim interdict granted in favor of the Zimbabwe Immigration Federation. The interdict prevented the arrest and deportation of the holders of Zimbabwe exemption permits, so-called ZEPs. The Supreme Court of Appeal ruled on Friday that the interdict must remain in place pending further court proceedings by the Federation. The Federation is seeking a ruling that the minister has no authority at all to terminate the ZEP regime. The permit was introduced in 2009 because of the wave of Zimbabweans that were entering the country at the time. Many of them are undocumented or without the relevant documentation. So, where do things really stand right now? Because this matter is also quite layered. But let's get a bit more perspective. Joining me on the line is the Zimbabwe Immigration Federation's chairperson, Benjamin Kenichi. Good evening to you, sir, and thank you so much for joining us.
Good evening, and thank you for having us.
I must say also before we get into the conversation with you, Mr. Kenichi, that we had invited the Department of Home Affairs or anyone from the department to join us in this conversation, but we were unsuccessful and we got no response to our requests. So this is why if the conversation comes across as if one-sided, well, that's because the other side declined to participate. So, Benjamin Kenichi, if I can just ask you at the beginning to just explain to us and paint a picture for us, because as I said, this is the case. Things get a little bit confusing because there are overlaps with the action that you yourself had pursued in court, along with that was pursued by the Helen Suzman Foundation. Maybe just let's start with you assisting us to separate the issues here.
Thank you very much for the opportunity for us to be talking to you and to your listeners. But I just want to correct something here before we go any further.
Absolutely.
That the ZEP was made out of undocumented Zimbabweans. I just want to correct that.
Okay.
Because almost 70% of the ZEP holders were actually people that were legally in the country, and they were under the asylum system.
Okay.
And if you look at when the dispensation of Zimbabwe permit was introduced in 2009, it was addressing the issue that the asylum system was overwhelmed. So because they reckoned that those people that were on the asylum system were actually people that had genuine consent. So if you look at it at that time, it is not every Zimbabwean that was moved over to the dispensation or to the special to the special exemptions that are under Section 31 of the Immigration Act. It was only certain people that were targeted, and also there was a lot of verification that was done, including police clearance and so on and so forth. So those people were not illegal immigrants at the time, but the issue was that the immigration system, the asylum system was being overwhelmed. That's why most of those people were moved over. I understand there was other people also that would have acquired documentation irregularly, and they were also given amnesty at the same time, and was also moved over to the ZEP permits, but they were moved over but based on that amnesty that was given to them, and that's a very insignificant number of around 8%. So I just want to put that point clear there.
Okay.
That ZEP holders were not undocumented people. They were documented people. Some were documented irregularly, but the bulk of the ZEP holders were actually from the asylum system. And the minister at the time, one of the reasons that were given there was because the asylum system was getting overwhelmed. So it was better to move them to the special dispensation, which was the DZP.
All right. Thank you so much for that clarification. I stand corrected.
Right, and then moving over now to the, I understand you asked about the difference between the Helen Suzman Foundation case and
Yes.
in the Federation's case.
Right.
So I think basically what we were praying for was similar at the time, because in 2021, as you may know, that the exemptions or the ZEP permit was discontinued. So the Federation, both the Federation and the Helen Suzman Foundation, were looking for an interdict that protects ZEP holders for a certain period of time pending. For the Helen Suzman Foundation, it was they asked for an interim interdict pending a fair process. So their argument was that the minister made a decision not to continue with the ZEP permits, but did not follow a fair process, and it was important that he does that. And the High Court agreed with their prayers, and they gave them an order according to those prayers. But the Federation's case also was almost similar. It was looking into the fact that the minister did not have jurisdictional authority to decide on whether the ZEP permits can be terminated or not. So if those that would have listened to our case on the 13th of April in 2023, they would have heard our argument, our ultra vires argument, that looked at Section 31(2)(b)(2) of the Immigration Act that speaks about good cause. So the Act itself allows the minister to give to persons or to a group of people exemptions according to based on certain special circumstances. So if you look at the reason why the regime of permit was instituted in the first place, it was because there were special circumstances, and based on those circumstances, the minister, the section allows him to do. But then, in terms of withdrawal, the section speaks of good cause. So good cause, that phrase "good cause" is a huge phrase, because the reason why I'm saying it's a huge phrase in terms of in surrounding this case is because good cause speaks to some of the constitutional rights that would have been acquired by the ZEP holders over time. Just to cut the long story short, we presented that to the High Court in Gauteng, and they did agree with us. That's why we got the order that we got. And what that means is that our challenge was with the jurisdictional authority of the minister because of the constitutional rights that are involved, and also rights that are enshrined in the Bill of Rights. And I don't know if that is answering the question that you have asked.
Oh no, it definitely is going some way to helping us understand the separation, because I know that there were certain parts of your case that were contingent on what the outcome of I think there were two parts to the matter that was heard. I don't know whether it was, and this is where you're going to need to help me along here, whether it was your case that was divided into two parts, or the case of the Helen Suzman Foundation.
Yes, you're right. So the Helen Suzman Foundation was asking for a final relief, and the Federation's case was divided into two parts. The one was Part A, where we were praying for interim relief pending the outcome of Part B of the case. So Part A was basically looking for protections, because at the time there was an emergency. That's why you see even the Helen Suzman Foundation was involved, and also the Federation was involved. And in both cases, we were praying for interim interdict or temporal protections pending for the Helen Suzman Foundation. It was pending the outcome of a fair process that would be conducted by the minister. But for us also, it was pending the outcome of Part B of our case. But then it was important that there were those protections, because quite a lot of things were happening at the time. People were getting held and arrested and declared by the minister undesirable when there are ZEP holders and processes that were actually supposed to be followed were not followed, or there was no jurisdictional authority where the process were followed.
Right. So, all right, it's starting to become clearer now. What are the implications of? Firstly, let's start with the ruling that was made on Friday. This unsuccessful attempt by the Minister of Home Affairs to overturn the interdict which had been granted in your favor. What are the implications thereof? What does that actually mean then, in terms of the status of ZEPs?
So the minister's challenge was to say for us, we were actually surprised when we heard that the minister had launched this an appeal against Part A of our case, because first of all, legally, you would have to have a very compelling reason to appeal an interim interdict. And we were surprised that that appeal was granted, but the courts have their own way of working, and they make their own decisions. So we cannot really. But that's the case. We were really surprised. But then the minister was challenging the fact that the protections were restricting the ZEP holders from being arrested and from being deported and from being handled or dealt with according to Section 19, Section 20, and Section 32 of the Immigration Act. So what that means is that the minister was saying, I still need to have the power to deport ZEP holders. I still need to have the power to arrest ZEP holders. So if you look at the lives of ZEP holders, it become very difficult in terms of, for example, many ZEP holders were getting arrested, and some of them were getting arrested and they would be returned back from the court when the court order was presented and things like that. So there was quite a lot of confusions. Some of the ZEP holders' accounts were being closed, and some of the employers were dismissing ZEP holders because of all these confusions that have been happening. So the SCA ruling is a relief to ZEP holders, because what it's saying is that the protections that were given on the 28th of June 2023 have been restored, or have been rubber stamped to say that ZEP holders cannot be dealt with according to the order of the 28th of June 2023. So that's where most of the relief is on ZEP holders, because most of them were living in fear. Most of them were struggling to actually live, because how can you be employed and your bank account is closed? Where is the salary going to go into? So some of the employers were just because some of the employers were just realizing that it's becoming very difficult for us to be employing this person, and they let that person go. And not only that, it's quite a lot of support that you should be getting when you are contributing to an economy and you're also legal in a country. Some of that support could not be given to ZEP holders. So those are some of the challenges that we were having, and that's how it is important that this that's how this ruling is very important for ZEP holders.
Where do things currently stand? Because now my understanding is that, of course, the validity of the ZEPs was now had to be extended, because there's also now the process of, and I don't know whether regularizing it would be the right word, or at least where ZEP holders were required to apply for the relevant permits and visas to be, whether it's a study permit or rather a visa to be a student, or whether it's a work permit to be employed in this country. They had to now go through that process, and these are people that have been, in the country, and as you said, working with the under as a benefit of the ZEPs, that now had to reapply with a process that by all accounts has been quite complex, and was even had to be modified, because some of the requirements, like individuals to advertise in newspapers and so on, even had to be revisited. Where do we currently stand in as far as that's concerned?
I think in the wake of the court order, it is after the 28th.
The latest court order, or which court are you going to have to remember to tell us which court order you're referring to, because there have been so many.
I'm referring to the court order of the 28th of June 2023.
Okay.
So the two court orders were clear, and the first court order was saying that the minister should follow a fair process of consultation with ZDP holders, and then come to a decision whether to extend or not to extend the ZDP permits, which is still underway. And the second order was saying that the ZDP holders have been given protections in the interim while we wait for the hearing of Part B of the Federation's case. But going back now to those the issue that you spoke about now, that there was efforts to migrate people from Section 31 of the Immigration Act to Section 19 of the Immigration Act. The challenge with that was the stipulations that were there. So if you look at most of the ZDP holders, not really most, but a bulk of the ZDP holders are teachers. And most of them, we've got also quite different sets of professions that we have within the ZDP community. But when you look at all those professions, what happened is that when the minister said that he has given temporary exemptions, which were called waivers, for people to be able to move from ZDP to other permits or to the mainstream visas, to the mainstream visas, then the Department of Labor went on also to put stringent measures when it comes to how people would apply, ZDP holders would apply and all that stuff. So legally, all of it would become illegal at the end of the day. So there was quite a lot of things that were a challenge there, to say then how do you do that, because it became very difficult for ZDP holders to be able to migrate to the mainstream visas, because the measures that were put in place by the different departments were very stringent, and they made it difficult. One example that I would give is where you were required to go and get a medical certificate from a police clearance, from 3 countries that you have lived in the past 5 years, for example. So that is just saying you can't. So when you look at some of those, you just can't. And the only country that you have stayed in is South Africa over the past 5 years. So it becomes very difficult. You go to any country that you go to, they don't know you to be able to give you a police clearance. I'm just giving an example. It's not that. It was quite a lot of them. And for people to end up saying, probably we need to get litigation here from a neutral body, which is the judiciary. It was because it had become very difficult for people to maneuver, and it just went more and more looking like whatever measures are being put in place are restrictive, and they're just there to restrict ZDP holders to move to the mainstream visa. That was the situation at the time.
You said something just a short while ago when you started to delve into this matter, respond to this question about a lot of these things, most of them being rendered unlawful or illegal. How so? Can you just explain what you meant there?
Okay, so what I was trying to mean there was that there was some of the requirements that were put in place would mean, for example, that if a ZDP holder was to move from the ZDP permit into any other visa, I think you would have heard the minister in his reasons for termination, that one of the reasons that he gave was that the ZDP holders, he was terminating the ZDP permits because about 9,000 of the ZDP holders had tried illegally to to move from ZEP permits into the mainstream visas. But if you look at it, those people had actually gone into Home Affairs and applied legally, but then because of some of the clauses that were in the ZEP permit, that some of the clauses in the ZEP permits did not allow them to do so, but they had gone to Home Affairs to apply. So it was either supposed to be a rejection or it was supposed to be, but then the way it came out now, they were considered to be illegal. So it was scary for ZEP holders to be able to decide to say, I'm deciding to move from here to the mainstream visa because of some of the restrictions that were in those permits.
Okay, that makes sense. All right, my guest this evening is Benjamin Kenichi. He is the chairperson of the Zimbabwe Immigration Federation. So, what happens next? What are we looking? What should we be looking out for in terms of this saga? It is quite a protracted matter, and that is so. It's got so many layers as well to it.
Yeah. I would like to say it's been a very frustrating journey for ZEP holders. One of the examples I can give is that according to the court order of the 28th of June 2023, the Federation was supposed to have filed Part B of our case in June 2024, on the 27th of June 2024. But the challenge, we did file our notice of motion at the time, and we never got any feedback from the minister for more than 9 months. And what we got after waiting for so long was an appeal against Part A of the case. So where there was an appeal in place, we were not able to set down Part B of the case. And what that means is that it means a longer term for ZEP holders, a longer term of uncertainty for ZEP holders. So now with the SCA ruling that came in last Friday, what that means is that we can now go ahead and file Part B of our case, and also get that case heard. And I think it would be best for ZEP holders if that case is heard quicker, so that whatever outcome it is regarding that case, and then people can just follow whatever the courts say, and also it brings certainty to the future of ZEP holders.
So let me just something that came also needed some clarification on a report that I was reading about the judgment handed down by Judge Unterholzer of the SCA. It says here that the matter came before the Supreme Court of Appeal in an application by the minister to have Part A order set aside on the basis that the pending review in Part B was now moot, given that his appeal in the Helen Suzman Foundation matter his appeals had all been rejected, and he was now following a fair process as ordered by the court. That fair process, is that ongoing? Do holders of the ZEP experiencing this fair consultation, this fair process?
No, not at all. I think one of the questions that were asked to the legal representative legal representative of the minister in the court was to say, have you started with the process? Because the consultation process was supposed to start in June last year, 2024. And what the minister said was that he had not started the consultation process, but he had given a directive to extend. And the court asked the lawyer to say when the extensions the extension was done, was there consultation? Because that's what the court order is talking about. And there was no consultation. That's the truth of the matter.
This is the extension of the ZEP.
Yes, yes. So there was a directive that extended the ZEP by 1 year. So the question was, has the minister consulted? Because we cannot say the minister has started But because yes, he has said he is committed to start the consultation process, but then commitment is not doing it, because we're talking about real people with real problems here. And commitment is not enough where there is people that are struggling and where there's people whose lives are endangered. So basically, the consultations have not started, and we probably 9-10 months after June. Actually it's 12 months now, and those consultations have not happened. So
and what is it? What form is this consultation supposed to take?
So it really entirely depends on the minister. But then what that means? I'll go back to Section 31 of the Immigration Act when it talks about good cause. So what good cause means is that the minister would have to consider. There's quite a number of things that the minister has to consider, but one of the things that the minister mostly has to consider is if the exemptions are withdrawn from ZTP holders, what would the impact be to their lives and to the rights that have been granted to them, and then make a decision based on scientific numbers and scientific figures regarding how that decision, not to extent, would affect them, and also that the minister should provide an alternative. So if you look at the minister's arguments in the Supreme Court of Appeal, he mentioned that there were alternatives, although he could not mention what kind of alternatives are there. And so that's basically how Section 31 of the Immigration Act, that good cause phrase that I said is very important. It speaks to the state of the ZTP holders, if I'm referring to this case in particular, but to other also people that would be under that section at large. But what that means is that when you're going to withdraw those exemptions, or when you're going to terminate those exemptions, you need to consider the impact on the person or on the persons that are sitting under that section, to say what does it mean to them?
Because it seems the minister was of the view that they cannot be deported.
Exactly. So when you look at that, that's not good cause. And also the judgment of the 28th of June 2023 actually pinpointed that, to say that the minister did not demonstrate good cause. And that's why the minister did not win that case in Part A of the case. Yeah.
Okay. And then just remind us again now, when this Part B that you've been waiting, what is it, 2 years, for Part B to be heard? Do you now just remind us exactly what that will be now, and whether do you have any idea when that will be heard?
We don't have an idea. The process is that we will have to file. I mean, the SCA has given us permission to file, so we're going to file. And when we file, the Gauteng High Court will decide when it's going to be heard.
Okay.
And also they would have to consider. I mean, we will have to also make our presentations so that they can consider if it should be considered as an agent matter or as an agent application or not. But then they would also have to make that decision.
So when you do file, you'll be filing on an agent basis.
Yes, that's we will have to file on an agent basis. Like I say, there's been quite a lot of things that has been happening to ZTP holders, their lives and their livelihoods, and I think we are anticipating that it will be considered to be an agent matter. Yes. Okay.
Finally, before I release you, I want you to comment on these two. It's nothing particularly new or interesting in what it forms, but it's a sentiment that is widespread that I'm sure you are familiar with. I'm going to read you these two comments from listeners on Twitter. It says here, Ramu Tsirisi says, "Good evening, Titi. Titi, why can't these guys take that energy that they have, fight our government in our own country to fight Zimbabwean president?" And then another one says, "Concerned citizens, Zimbabweans are cowards. They will spend every cent fighting to be in South Africa while President Mnangagwa is enjoying Zimbabwean minerals with his family and friends. Why can't they go teach clean cook in Zim? what is it? Some of them are criminals. As I said, nothing new in those sentiments expressed, but there are sentiments that are out there. How do you respond to that sort of thing?
I do understand what how frustrating this can be to people that we respect and people that host us in this country. And I do understand that, but I think sometimes also we need to be a bit factual about some of these things, and some of these sentiments and where they're coming from. Because when people talk about fighting, people don't go to court to fight. People go to court for litigation. So for us, for the Federation to end up going to court, we made efforts to seek audience with the minister several times. I think if you listen to part A of our case, we did present that in court to say we made efforts to go and to seek the minister's audience so that we can discuss with the minister and also air some of these issues, because these are real issues affecting real people. The world has survived for more than 300,000 years, and there have been wars, and there have been misunderstandings, and all that. But then I think what has remained is human beings. Human beings have always survived over the years, and the reason for that is because people treat each other with respect, humanity, and that's what's important. And one other aspect that I want to talk about is the issue of South Africa itself being a constitutional democracy. That's the difference between South Africa and Zimbabwe. And I think at some point we need to decide as humanity whether we want to be a constitutional democracy or we want to be an autocratic system of governance like Zimbabwe is.
Okay.
And,
all right.
So the fact that ZTP holders decided to go and look for litigation is not fighting.
Okay.
It is not fighting at all. It is seeking a neutral person that can litigate between two parties that are not agreeing with each other.
Okay.
So if it's labeled as fighting a government, it's not fighting a government. It's saying we are people that have been affected. I spoke earlier on about the bulk of the people that are ZTP holders now, that they were in the asylum system. So those are people that came into the country and say, I want to be recognized. When you are applying for asylum in South Africa, you will have to have a proof of residence. You will have to have your passport. You would have come in here with a passport or with a temporary travel document that is taken and kept by the Department of Home Affairs. And you are given that asylum in exchange for your passport.
Okay.
So you are a person that the government knows where you are. They have your fingerprint. So you are not. You are not. I can address the issue of somebody that said that most of them are committing crime. There's no ZTP holders that are committing crime. I would explain to you what happened when people got ZTP. People went in. They were vetted. And you were not supposed to have committed any crime, including drunk driving. There's people that had crimes of drunk driving that did not get into they were not given the exemption because of that. So it didn't matter how petty a crime was. You were not going to get the exemptions.
All right, we're going to have to leave it there, Benjamin. We are out of time. I've actually kept you longer than we had anticipated, and I do appreciate your indulgence. Thank you so much for your time this evening.
Yeah, thank you very much for having us, and good night.
Thank you so much. That's Benjamin Kenichi. He's the chairperson of the Zimbabwe Immigration Federations.